All right, I'd like to go ahead and get started now and thank everyone for attending. And this is a webinar hosted by me. I'm David Taylor, and my firm is Twin Falls Estate Planning. I'd like to just go ahead and do a brief overview of housekeeping. First off, all the participants are muted, and we will have a Q&A section during the end. But if you have any questions along the way, feel free to raise your hand or drop something in the chat. I'll give a little bit more instructions on that in just a minute. And otherwise, we'll just go ahead and get started here. And all right, great. We'll go over a few more things about how to run this, but go ahead and just get started telling you a little bit about me. So I'm an attorney. I grew up in the Boise area, but I've lived here in Twin Falls for a few years now. And I feel kind of like a Twin Falls native. My wife and I were married here. She was from Twin Falls. She graduated from Twin Falls High School and got out of Dodge. At the time, Twin Falls, there wasn't much going here, so she left Twin Falls, and we found our way back, and we've been very happy. We were blessed with boy-girl twins. Nothing like having twins when you're in your 30s in law school, but somehow we did it, and we endured, and here we are. And just a little bit about my practice history. Because I feel like it's all, yes, of course, here's a picture of my family. This was taken just under 2 years ago. But we, again, we love it here in Twin Falls, and about the only thing we miss from the Boise area is football, but what can you do about that? So I just want to share a little bit about my story, and then we're going to go into some of the logistics, because I want this to be an educational experience. But as I share this story, the reason why I share it is because I want to make sure you know what's out there, because there's lots of options for estate planning. There's online options, there's attorneys who do it, that you can sometimes find a bank who might dabble in a few things, or a financial planner. So I just want to share a little bit about my experience, and that will also educate you on some of the options that are out there. I actually interned at an estate planning firm, and this was over in Eagle, Idaho, and I interned there for about 1.5 years in law school, and I enjoyed my time there. And then after I was done, the attorney who was a lifelong friend said that I needed to go out and explore and be a transactional, the traditional attorney. You know, he said, go to court, make some lawyer noises, and learn how to be an attorney, and then circle back to estate planning later in your years. And he wasn't wrong about that, but I did just as he said. I went out to be a traditional attorney, and I was, let's see, I was a prosecutor. You know, estate planning was usually my primary focus, but I did commercial litigation and all these things. So I was your transactional, your traditional attorney. And I didn't like it, and I hated it, actually, and everyone hated me. You know, as a traditional attorney, it's very confrontational, and everyone, I mean, my bosses hated me, the court hated me, and the assistants wouldn't even say hi to me. It was just not a good environment. It's a toxic environment, and I understand that it's needed. You know, I'm not saying that we should do away with the whole legal system or anything like that, but it wasn't for me. But more importantly, I hated the way that estate planning was done. And the traditional attorney approach to estate planning it's very interesting. And I'll just give you a brief history on how it's done, how an attorney gets into estate planning. Pretty much it starts in law school, and usually there's like a guest speaker who comes and says, hey, you know, do estate planning. Draft some wills and keep the original wills, and someday when your clients die, your clients are going to come back, or their family's going to come back, and they're going to pay you lots of money to probate the case, and that's going to be your retirement. And with that knowledge, then the attorney goes to work, and pretty much the way that they learn estate planning is they call up another attorney who practices estate planning, and they say, hey, I landed a client who wants to do a will, what do I do? And that attorney says, well, I'm going to send you a will that I did, and you just basically copy that and change the names. And if you don't believe me, that's absolutely how it goes. Even when I was a traditional attorney, that's the client interaction. Is the client would come in, and we basically would say, okay, well, you know, who do you want to do what? And then we'd go back to the last document we did, change the names, and out you go with it. And I found that it was not very effective. The practice of estate planning was geared for or meant for like someone there in their 80s or 90s. It wasn't really a comprehensive plan. But the worst part was that you made the client feel like they had everything accomplished, they had all their hopes and desires set, and then once that client passed away, then their family approached you and said, "Yeah, mom said that she went and saw you and got everything taken care of, and now we're here. What do we need to do?" And we say, "Well, pay us thousands of dollars so we can probate your case." And that usually your family members like, "Well, what the heck is going on? I thought everything was taken care of," and it turns out no. And so I moved away from that traditional approach. I eventually started my own firm doing estate planning the way that I feel it should be done, which is essentially to provide a client with information. And I'll talk about that a little bit more, but I like providing an education. I know that the name of this webinar is Why You Need an Estate Plan, but probably a more appropriate name is Why You Need to Get an Education to Determine Whether You Should Do an Estate Plan, because that's the most important thing, is knowing what your options are. I don't take the approach where a client comes to see me and I just take down some names and put together some documents and off you go. So I say that just to let you know that I believe that the traditional model is broken. It's so easy to find estate planning done online and estate planning done by attorneys who treat estate planning like a hobby. But I like to look for the clients who want to get a comprehensive plan, meaning that they want to put together a plan that will make things easier for their loved ones. So with that, just a few disclosures on here. First off, this presentation doesn't have legal advice. This is, again, meant to be something that's educational, and you can use this knowledge to either help your family take the right step in the next direction, or you can wow your friends at the next bar trivia night. Either way, hopefully we should have some fun and get some education. During the Q&A session, I'd like for you at any time you can either raise your hand or you can put something in chat. If you put your question in chat, you can put it to the group or you can send it to me individually. I'll do my best to make sure that question gets answered. But just a small disclosure, legal advice involves facts. And so if you ask me something like, hey, what should I do with my dad or what should I do with my mom? That's a little hard to answer because I feel like I'm giving legal advice. So I like to, if possible, I want you to feel free and ask me the questions, but I'll tell you, I prefer the questions that are more, general, like what's the difference between a will and a trust? How much does this cost? Things like that, a little more general. Quick overview of this educational session. We're just going to look at some of the basics of estate planning, and then we'll talk about why you need an estate plan. I'll give you some tips on how to start your plan, and then we'll turn it over to a questions and answers session. All right, so I want to go ahead and start with a poll, and this is somewhat of a trick question, but it's always an appropriate question to ask. I just want to know, and I don't have names, this is an anonymous poll, but who has an estate plan? Go ahead and enter your answers in on your device. We'll leave it going for about 30 seconds or so, but I want to know if you have an estate plan done. Did you go see an attorney and you got your will done? Did you maybe go online and you got your will done? Do you have a trust? Did you handwrite your own estate plan? Maybe one day you just sat down and said, I've got some concerns and I'm going to write a few things down. So we've got a few results, and it looks like about half of you have voted, and we're split about in the middle. I have 2 people who have said yes, 2 people who have said no, and I have one who said sort of. And I get that sort of, because some people have something done and maybe it was done years ago and they're just not sure. So I get that. And what I'm going to do now is we're going to end this, and I'll share the results briefly so you can see them. So there we got 2, 2, and 1. All right, so of course, like I disclosed in the beginning, that's a trick question. And the reason for it is because everyone already has an estate plan. And it's the estate of the government, meaning that the government has a plan for you. And that plan is what happens for you in the event that you're incapacitated. That plan is what happens with your property when you pass away, how it gets administered, And that's all set up in the state of Idaho. It was 1974 when Idaho adopted the Uniform Probate Code, where a bunch of attorneys and legislators got together and they said, hey, let's create a plan because we recognize that everyone's going to have a will. So believe it or not, even if you have not gone to see an attorney to get something done, you have something done. And we'll talk about this a little bit more, but even if you have a will, you're still somewhat subject to the government's plan. And you have an option where you can either accept the government's plan or you can reject it and create your own plan. And I don't mean to at any point sound like I'm anti-government, but just as I said before, it's important for you to understand the government's plan. And every now and then when I tell a client what the government's plan is for them, a client will say, you know, that sounds okay, or I'm not worried about it. It's usually the husband like, I don't care, I'm dead, what do I care? And that's fine, you know, at least you know what the options are. But I'm going to tell you right now, the government's plan ends up being costly. And a lot of times people ask me how much it costs to get an estate plan. And it's hard to answer because you need to understand that there's a cost with that even if you don't get an estate plan. What I mean by that is just by default, when you pass away, let's say you go through probate, and which is likely going to be required. I mean, the starting price for probate is $2,000, so it just moves on up from there. So all that to say is, yes, you do have a plan, and I hope to share with you a little bit about that plan for you. So let's talk about the basics of an estate plan. And when we talk about an estate, this is sometimes what we think it means. I think that's just our culture. We think of the Downton Abbey, you know, the mansion. But really what it is it's the stuff. It's, you know, if you're 18 and in college and all you have to your name is a Boise State blanket that your sister made you, that's your estate. That's your stuff. And a lot of times people will come to me and say, David, should I be worried about getting an estate plan done because I don't have a lot of stuff? And I say, well, the fact that you have stuff means you should at least look into it. Property ownership is a big one, real property ownership. If you own a house, I don't care if you have a mortgage or not, but if you own a house, then in the eyes of the government, you have an estate and you will be required, well, not you, but your family will be required to go through probate if you own real property. So, you know, again, I think the point I'm getting at is this is not for the rich. If you own stuff, then you should look into an estate plan because we need to figure out what happens with your stuff. And here's what an estate plan usually entails. Here's what we look at solving problems for. Here's what we want to do is we want to create a plan, and that plan comes into effect. And if you're looking at this, this is what I call the possible scenario, and this is, of course, the inevitable scenario. So possible, you may be at a point where you're incapacitated. You might be able to be at a point where you can't think for yourself. We call that incapacity. I try my best not to throw around these lawyer words, but that's just one we have to deal with, incapacity. We can call it Alzheimer's, dementia. It could also be just you're at a point where you know, you're no longer thinking for yourself, maybe like a car mobile accident. You're probably going to leave this webinar and be like, I don't want to drive again. But that can happen. You know, you're involved in a car mobile accident, there's brain damage, you're impaired, and you're no longer able to think for yourself. I'm actually involved in a guardianship case. We'll talk about guardianship in a minute, but this client was involved in a car mobile accident in 2007, and bless him, he's just never been the same ever since. So it happens. Even me, you know, I'm not even 40, and I have a comprehensive plan for incapacity. Why? Because, well, two reasons why is because I want to make a plan for if I become incapacitated, because you never know what happens. The second thing is for my kids, because if I become incapacitated, then it's very likely that the government is going to take the kids from the house until they figure out what to do with them. The second one is death. So we make a plan for incapacity. We make a plan for what happens when you pass away. And I'm one of the few attorneys where I try and avoid court. And in both of these scenarios, court is likely unless you have a plan in place, whether that be under incapacity, you're talking about trust documents, or you're talking about power of attorney, healthcare directives. a simple plan in place can avoid court altogether. So I'm going to expand a little bit on what we were talking about before. Remember when I said that the government has a plan for you? I call that the plan by default. So the government's plan is basically a one-size-fits-almost-no-one plan. It involves courts, lawyers, judges, and that's what the law says. If we don't know what to do with you, then a judge ultimately has to determine what to do with you. And you're stuck with that plan unless you create a comprehensive legal plan that says otherwise. The plan by design, basically a plan by design includes whatever. It could be simple documents, could be simple legal hands, it could be comprehensive legal plans. This does not mean, oh yeah, I want my money to go here, and I want my money to go there, or I want my kids to get a certain amount here. Like, all it means is that you have something in place because you don't want the government's plan, or maybe you just want to help simplify things if you are subject to the government's plan. And whenever I meet with my clients and we talk about these documents, what I like to tell them is we create a plan, and I call it a framework. We create a plan about incapacity, about death, and I don't like my clients to be too caught up in the weeds of what these documents are. I basically tell them, we have a framework, and that framework comes into play depending on the situation. We put it in about 7 different documents, whether it's this power of attorney, revocable living trust. Doesn't really matter what the document is. The attorneys are the ones who figure out what the document is based upon your concerns. All right, so let's talk about the plan by default, because I think it's important for all of you to know. So as it relates to your finances or your general well-being, if you are ever at a point where you're unable to make a decision for yourself, then without a comprehensive legal plan, the government requires a judge to determine whether you're incapacitated. This is through a court proceeding called guardianship, or maybe you've heard of a conservatorship. Either way, it's about the same thing. It starts off with a petition, and by the way, this is also if it's uncontested. You can't just show up with 3 or 4 people and say, hey judge, no one objects, can we be this person's guardian? It doesn't work that way. It commences with a petition. So someone, spouse, child, friend, whomever, has to sue you, basically, take you to court, give you notice of the hearing, and present you before a judge and say, judge, I think that mom or dad is not able to think for themselves, and I want to be awarded guardian of them. And the judge says, well, that sounds good. Looks like no one's objecting. So what I'm going to do is I'm going to require, because the law requires, I don't mean to pick on the judge, but I'm going to require now all of the proceedings to happen, all of the investigations, all of the fact finding, and that takes, if it's uncontested, maybe a month or 2. If it's contested, it could take longer. And then all of a sudden, there's a bunch of people who show up. There's a court visitor. There's what's called a guardian ad litem, a bunch of fancy lawyer words. All this to say that at the end, what ends up happening is the petitioner, the person who believes you're incapacitated, the son or daughter, goes back to the court and says, judge, we did everything we asked you to do. Can I be appointed the guardian? And the judge says, yes. With some strings attached, you need to report back to the court at least once a year. I want to see how things are going and make sure that you're providing the best care that you can. All of that can be avoided with some simple planning. A power of attorney can avoid that if it's done right. But that's what you're subject to. If you don't have a plan for incapacity, and if the scenario happens, that's the solution, is we got to take you to court and sue you. And I always, my heart aches for these type of hearings. And usually it ends with the client saying, David, this was completely unnecessary. Why do we have to do this? And I say, you don't have to if you create your plan. But if you don't, then yes, you have to. So incapacity as it relates to healthcare. Now, healthcare is a little bit different. And when it comes to your finances, what we're trying to avoid when we create a plan for you is we're trying to avoid that hearing. We want to take it out of the court's hand. In relation to your healthcare, what we're trying to do is we're trying to overcome these hurdles. We want to make it clear to the medical staff what your plan is, and otherwise, here's the scenario we don't want. We don't want a scenario where the medical staff has to make a decision, where there's a decision that needs to be made and they have to run it up their ethics committee, wait for the ethics committee to come back and hand down a decision, talk with the family members. You know, there's these implications of healthcare are more serious than your finances, because we care about you. I jokingly say I care about my clients, not their money, but that's because, you know, we want to make a plan for you, not just your money. So that's what healthcare documents are all about. When you can't make a decision for yourself, who can, and how can we make it simple for them to do that? All right, so we'll talk about this a little bit more, but now let's switch to death. So what happens to your property when you pass away? Well, the government has a plan for that, and it's a pretty simple plan. It starts off with, if you're married, everything goes to your spouse, okay? If you're unmarried, everything goes to your children, all right? Now we start getting a little bit more into the weeds. If you're unmarried and have no children, everything goes to your parents. And lastly, and I'm actually involved in a court case right now, if you're unmarried, have no children, no parents, and everything goes to your siblings. Now, the question is, what can go wrong with that? And we're going to find out here in just a second. But here's the thing is that might sound okay, and you might be listening to this and say, you know, that's not too bad. I'm okay with my property going to, you know, my siblings or something like that. I'm not. And I can say that because one of my siblings is on this call. He's my brother Chadwick is a helper of mine, so I can gladly say I don't want my money going to him. So, you know, as you're looking at this, you might say that's not bad, but here's the other part you may not be seeing. It's the process of how that property gets to them. And that process is through probate. And what is probate? Probate is a lawsuit. Probate is a court proceeding where one of your loved ones needs to come and sit down with an attorney and pay lots of money to have everything distributed when you pass away. Costly, it's somewhere around $2,500, maybe $2,000 to $3,000 if you're unmarried, probably closer to about $3,000 if you're married. It's just not very friendly. It takes 6 months. Some exceptions apply, but even between spouses, there has to be some form of probate. And I get this question a lot of what is probate? So I just wanted to take a minute and explain the framework of how it works. So if you die and you own property and you're required to go through probate, then the first thing that happens is someone, spouse, child, someone needs to go to court, probably hire an attorney, and they need to be able to get appointed as what's called the personal representative or your agent. There's usually one person who's running the show. And in order to do that, even if you have a will, they have to go and, you know, basically file some court documents and get appointed by the judge. That sometimes requires others to sign off on it. And I'm involved in a court proceeding right now where we have one person who's not signing off on the paperwork, and now we're required to go in front of a judge and have a hearing, easily costing $1,000 more than the normal probate case because we got to go to court because one person refuses to sign the paperwork. So next, after we overcome that, so we get you appointed, then the next thing that happens is what we call the inventory. So within 90 days, we're required to determine what you're worth. And not bad, except that it becomes public record because that has to get filed with the court because there's two interested parties of your estate. There's what I call the creditors and the beneficiaries. And I don't care if you say that I have all my debts paid off, we still need to make a plan for notifying your creditors that you passed away. And they need to know what's at stake. And so we have to file that with the court. And some people, you know, look at that and say, well, I don't want my neighbor to go down to the courthouse and say, well, I want to see what he was worth. It's a matter of privacy, but that's what happens is we have to do this inventory. The next thing we do is we have to notify your creditors through this archaic process called a notice to creditors. And this is done in a newspaper. You've probably seen these on your way to the comics. You know, so-and-so has passed away, and whoever wants to make a stake in their claim, speak now or forever hold your peace. You've probably seen those notices. Maybe someday those notices will be on Facebook, who knows? But for now, it gets published in the newspaper, and we have to wait 4 months before we know who the creditors are. We give them 4 months to come in and say, yeah, I'm owed money. Then after you get all that settled, you sell the home, you pay off the creditors, pay off whatever other debts you are, cancel the magazine subscriptions, whatever it is. Now we can get what I call the residuary, which is basically mean our pot, our money, whatever's left over after all the administrations are paid for. And by law, we have to allow 6 months for that to happen. So remember when I said that this whole process is for the debtors and the beneficiaries. We allow the beneficiaries 6 months to object. And maybe they object to what they're getting, or maybe they object to the way the personal representative is running the show. All they have to do is file a note with the judge that says, I object, and now all of a sudden it's a contested case. So we give them 6 months to object. After all of that time, then we can start handing out the money and divide things up. Now, I want to talk just briefly about a will, because I get a lot of questions about what's the difference between a will and a trust, and I'll answer it as best I can right here. If you have a will, you do not avoid probate. And if you take away nothing else from this, understand that, because that's one of the most common misconceptions I get is, David, I want a will so I can avoid probate. No, you direct the probate court. You can determine these two things here. You can say, this is who I want to be the personal representative, and this is who I want my property to go to. Now, that again, that's not a bad thing as long as you know what you're getting into. You're basically simplifying the probate process, and that could be okay. Again, if you have these discussions with an attorney or you educate yourself, that may not be such a bad thing. But a trust avoids this altogether. So with the will going through probate, we still have to do this inventory. We still have to do this notice to creditors. There's still work that needs to be done in court. And a trust basically takes it out of the court. And everything is administered outside of court, meaning that you set up a trust, you set up a plan, so that when you pass away, we just go by what the trust says, which is usually pay off my debts and distribute my money. Typically there's more to it, but that's in its simplest form. The difference between a will and a trust is a will directs the probate court. A trust avoids the probate court. And so now let's talk a little bit about more getting an estate plan. Why do you do it? Here's what I've determined is about the top 10 reasons why people get an estate plan. 10, kind of funny, I know, but to care for their pets. But I get that more than you think. Someone comes in and says, David, I want to make sure my pets are taken care of after my death. Okay. Avoid guardianship conservatorship hearings. Yeah, those things can get costly if they're contested, and even if they're not costly, they're not pleasant. And so sometimes people come to me, and that's a big concern, is they experienced a hardship. They experienced mom or dad going through incapacity, and they said, what can we do so we don't have to go in front of a judge? Maybe you want to provide a donation to charity. And maybe you want to protect a person from creditors, predators, and spendthrifts. What do I mean by that? This is a little bit more advanced planning, but you can set up a plan so that your assets are used wisely, even between spouses, and we can make sure that your assets don't end up going to the government, don't end up going through bankruptcy, don't end up going through some frivolous spending with creditors. There's some things that you can do with your assets that can really benefit someone else. And this one is for me. Number 6, nominate a guardian for a minor child. That was very important to us. We'll talk about that a little bit more. Some more reasons: provide for a person with special needs. We'll talk about that a little bit more too. And of course, 4 might be one of the most popular ones, even though people may not know it, meaning that when people come see me, they don't realize how complicated it is. And then later they say, yeah, you know what? I really do want to make this simpler. So number 4 is making things simpler. Number 3 is protecting privacy. We talked about that a little bit. Probate's a public proceeding, and many people don't want their assets or their life to be on display. Number 2 is avoid the pretermitted or unintended heir. And that's a bunch of fancy lawyer words, I know, but we'll talk about that a little bit more. That involves blended families. And when I say blended families, I'm talking about your stepmom, stepdad, stepchildren, some kind of scenario where your children are not your biological children. And of course, the number 1 is to make changes to the plan by default. That's the most common one, is someone hears something about the plan by default. They don't like where their property is going, or they don't like probate. and they want to make a change to it. So we have enough time, I think, to cover about six broad categories. I'm sorry, six narrow categories. If I had my choice, I would send everyone to go see an attorney to get an education, to learn what's right about them. What's right or wrong with an estate plan. You know, what is the law? What are the consequences? And then you can make an informed decision. But for this purpose, we're just going to talk about these six. And even if it doesn't apply to you, you might know someone. Let's start with parents of minor children. This is something very near and dear to me, because this is something that's often missed. And you know, parents of minor children, we think we're young and we don't think we're vulnerable. And you know, I know for my kids, they're very, of course, near and dear to us. We tried for years to have kids, and we eventually were blessed with these two twins. And it was a scary thought when, you know, we could finally leave the twins alone, and my wife and I can go out. And they were probably 3 years old, and no, I'm just kidding. They were a little bit younger than that. But you know, you start thinking as a parent, well, what would happen to the two of us if we're out on a date and we get hit by a car or something? What happens to our kids? Well, I've since researched that, and what I found is that even in a temporary situation, the government is likely to take the kids out of the home until they find a suitable housing arrangement, until they do the inspection, until they talk with the people who could be the potential guardians. You know, and that scares me. I don't want to see my kids taken out. It could be for an hour, it could be for 2 hours. But to me, when I did my first estate plan, we actually paid an attorney to do it, and that was the most important thing to me, and I'm glad we did it. We wanted to make sure that there was a clear direction on who is going to be the guardian of our children. And probably one of the hardest conversations I had in my life was talking to the potential guardians and telling them, you know, you guys are up if something were to happen to you. The other scary thought about, the other thing when it comes to parents of minor children is if something were to happen to them, it gets really messy in probate court. Children are minors. Minors can't inherit money. Children become beneficiaries of retirement accounts, life insurance accounts. It becomes very costly and very time consuming. You know, we have to the judge has to create a plan for them to last until they turn 18. Not pleasant. All right, so we'll move on to the blended families. And by the way, all of these we could probably do a separate webinar on, but blended families. So I mentioned before that the probate court was adopted in 1974, and if you think of what the conventional family was then, it's definitely not the conventional family now. It's very easy to create a scenario, not create, but the plan by default has a scenario where your stepchildren end up getting all the money and your natural children take nothing. And that's just kind of the way the laws are set up. And even if you do set up a plan, you need to do it right, because you might have the wicked stepmom, and this is based on the true story, and she called herself the wicked stepmom. I don't want you to think I'm being mean, but you know, this was a couple who each had their own child, so a blended family, got married about when they were about 30, and 30 years later, dad passes away. And, you know, they had an estate plan that said probably what you would think. When one spouse dies, all the money goes to the remaining spouse. When that spouse dies, then the money gets split between our two children. But life goes on. And 30 years later, so now mom is in her 90s, and she comes to see us and says, I want nothing to do with my stepchild anymore. Doesn't call me, doesn't want anything from me. So I want him out. And so again, that stepchild was a part of her life for darn near 60 years. And that stepchild's not going to see a dime from what his dad worked so hard to earn. So those kind of scenarios are ones where it takes some planning to do. And again, just knowing what your options are to prevent that from happening. Business owners, I'll tell you right now that attorneys who practice probate, and I'll admit I'm one of them, we love business owners in probate court because it makes attorneys a lot of money. Just be very honest with you, but to dissolve the membership interest, to work with the partners, And especially if you're billing by the hour, then you're going to make a lot of money trying to get everything sorted out. And you know, especially if you're a sole proprietor, if you're the one owner, it's going to get messy in probate court. And it's something that is just very beneficial to do. If I had my way with business owners, I would also help them create a comprehensive business plan. I don't always get that, but if I do get a business owner, I say, you know what, let's at least create a succession plan, right? Let's talk about what happens to you and your business in the event that you're either incapacitated or you pass away. I actually fear incapacity more than death as far as a business owner. Look, for example, at what's going on right now with our pandemic. I'm a business owner, and if I were out for 2 weeks, that would be very detrimental to my business. I do have a plan for that, but I don't think every business owner has. So that's probably my biggest concern is what happens if you can't work for 2 weeks? You know, who can do payroll? Who can write the checks? Who can make some decisions on your behalf? The conventional family. All right, so we're talking about a mom, a dad, son, daughter, you know, very conventional. And I'll tell you this now, perhaps the most complicated, costly probate case I ever was a part of involved a mom, a dad, a son, and a daughter, and every one of them had a will. Every one of them had a plan. It was a simple plan, but things just went awry very quick. And people died who we weren't expecting to die. You know, and eventually mom, dad, son, daughter all died in a matter of a few years of each other. And there ended up being a fight between a boyfriend and a grandson. And these are just kind of things that, you know, they didn't plan for. When they created their plan, they thought of plan A, not plan B, not what happens if. And that could have been avoided. So the conventional family, again, sometimes they come to me like, David, this is pretty straightforward. We know who's going to get our property. Yes, but do you know how they're going to get your property? Also, do you care about incapacity? So a rhetorical poll, because I sometimes ask my clients this, hey, take a step back. CPAs and sometimes, usually traditional attorneys will come to me and they say, you know, probate's not bad. 6 months, that's not bad. And I say, yeah, it may not be, but let me ask you this. Do you want to be a party to a lawsuit? Well, what do you mean? Well, if you had the choice, would you like to voluntarily be a party to a lawsuit? Well, no. Okay. Well, what about, would you want one of your children to be a party to a lawsuit? Well, no. Okay, that's what probate is. Probate is a lawsuit. Someone has to come, someone hire an attorney and go to court, file some court documents, and every move is governed by the court. And if there's a dispute, they go in front of a judge. It's a lawsuit. And if you had a choice between having a lawsuit or not having a lawsuit, you know, pick what you can. So the conventional family is often a good candidate for a trust-based plan. And I've seen many conventional families who do a will, and in my opinion, that ends up being a waste of money because they might pay an attorney, I don't know, $1,000, $1,500 to do a will, and then they have to go through probate, which is another $3,000, where for probably a little less than that cost, or maybe about that cost, they can just set up a trust. You know, I sometimes look at these wills after someone passed away, and I said, hate to say it, but the will doesn't really do us a lot of favors. We all knew that this was going to happen anyways. But long-term care. All right, so this is kind of interesting. How many people, this is rhetorical again, but how many people, if you have an aging parent and you're concerned with their well-being, how many people think to call their attorney? Yeah, probably no one. But here's the thing about long-term care is it's costly and it's unexpected. And usually your assets are depleted to pay for long-term care. And this is a very common story. I get calls from the nursing home care centers that say this person ran out of money and now they need Medicaid. So my very quick synopsis of this, Medicare, just to let you know, is health insurance. Medicare is easy. You turn 65, you get Medicare. We want to take care of you. Medicaid pays for your long-term care, okay? Medicare does not pay for your nursing home care. Medicaid does. And Medicaid is like a glorified loan from the government, although you do not know it. You don't sign a contract or anything, you just become eligible for Medicaid. And they keep track of every dime they spend on you. And when you pass away, then they want it back. And think about that for a minute. A nursing home is what, $5,000, $7,500, maybe up to $12,000 a month. You're in a nursing home for 3 years. I'm not very good at math, but that's a lot of money that ends up being paid back to the government, and not a lot of is left for your kids. But an attorney can help create an irrevocable trust that can A, help someone be eligible for Medicaid, and B, avoid having to pay back Medicaid. So again, not something you think of if you see someone who's in need of nursing home. You probably don't think, well, I need to call my attorney, but believe it or not, we can help with that. All right, and then this last one is special needs. So special needs is very similar to Medicaid. I'm sorry, it's very similar to what we were just talking about, nursing home care, because usually someone on special needs is a beneficiary of Medicaid. And it's what I call a government, a means-based government benefit, social Medicaid or social supplemental income. If a person is on Medicaid and they receive an inheritance, that's a problem. There's two things that are going to happen, and possibly both. As number one, they could be disqualified for Medicaid, or their inheritance will ultimately be paid back to the government. So if you happen to have someone who's on Medicaid, and if you don't like the idea of giving your money to the government, because a rhetorical poll, who wants to give their money freely to the government? Probably no one. It's something that can be fixed to make sure that it stays out of the government's hands. All right, so some general thoughts. So there's a plan for everyone, and it's what the state of Idaho says. And you should take the time to educate yourself on what the laws are. And I appreciate that you took some time today to learn, about this, because I think when it comes to estate planning, as you can tell, it's not just who gets my property. It's, is this the right decision for us? Do we want to make this? It's an investment. Do we want to pay this money to make a plan that's tailored to us to avoid these things or address our concerns? And the best way you can plan is to find the right plan. And what do I mean by that is, doesn't necessarily mean you spend more money. It just means more of finding out what's the best path. Many of my clients will find that we spend a great deal of time just figuring out what the right plan is. Do we go for a will? Do we go for a trust? How complicated do we want to make it? I spend almost 2 hours with potential clients just talking to them and educating them, and that way they can know what the best plan is. And whatever that means for you, doing your research, reading a book, hopefully seeing an attorney and talking about some options. And a lot of times people get caught up in these type of questions, and I get these questions all the time. What is a will? What is a trust? Do I need a trust? And it's hard for me to answer them because I went to law school, and most attorneys, if you haven't realized this, most attorneys want to share their knowledge. They want to brag about all the things that they learned in law school, and they want to tell you about these big cases they won. And so if someone just comes to me and asks me what's the difference between a will and a trust, you're probably going to get a 20-minute dissertation on the two. Whereas if I'm sitting there in front of a client and I can see their assets, I can say, okay, you have a house. Here's what it looks like if you have a will. Here's what it looks like if you have a trust. You have a retirement account. Okay, here's what it looks like if you have a will. Here's what it looks like if you have a trust. I tell my clients, don't get too caught up in the documents. That's my job. You focus on what you want in that framework, and I'll find the right document for you as far as getting that done. But before that even comes to play, you got to think for yourself. What do I want? What do I care about making things easier for my loved ones? Are you concerned about long-term care? These are things for you to decide before you start investigating it. Is what do you want? And then maybe you don't know, but that's why it's important to get that education. Because what's that saying? We don't know what we don't know. Yeah, many times someone in my office will say, I never learned about this. Well, I get it. That's why you pay me for that. They don't really, I never took a class on estate planning outside of law school. I went to Boise State and I got a good education in English writing, and I learned nothing about any of these laws until I went to law school. So I get it. And that's why I do these free webinars, is to teach people. Because as you can tell, my approach is not to get everyone in my door. My approach is to provide an education. And if you feel like it's something you want to get resolved, then let's talk further. Let's see. Yeah, budget prices. It's hard for me to answer the question of how much does a plan cost, because I have about 9 different plans ranging from $1,000 to $6,000 and even higher, depending on how complex you want. But it just really depends on what you're trying to accomplish. And we'll talk about that in a second. But I would say that one piece of advice is, if you're looking at options and you're seeing something that costs less than $1,000, I would be very cautious. When I think of all the work that goes into this, it's a lot of work. It's a lot of planning. And if you're doing anything for less than that, you might want to start questioning why. Or it might be something that, if that's all you're looking for to have done, might be easier just to do it online. Keep in mind too, there's also hidden cost. You might walk out of your attorney's office and you paid $100 for a power of attorney, but maybe that power of attorney is not good enough, and you end up having to pay thousands of dollars later on down the road. I see this a lot with Medicaid. I get calls from the nursing home and they say, so-and-so needs Medicaid, and this person has a power of attorney. And I say, yeah, but does that power of attorney mention anything about Medicaid and how they can apply for Medicaid, or how they can spend down their assets to be eligible for Medicaid? And if the answer is no, then Medicaid's not going to accept it. Medicaid has to see the words in your power of attorney document, whatever the code is, USC 42 CR or whatever. They need to see those buzzwords in order for it to be effective. So you might have a power of attorney that maybe allows someone to sell your house, but it probably isn't going to be comprehensive. Check in your mail. How many power of attorney documents do you think say check if someone's mail? Mine do, and the reason why is because one day some client tried checking the mail and they said no. We need to see the buzzwords in there that says we can check your mail. And so the power of attorney, again, you can walk out with a cheap one, but you could still end up having to pay for it down the road. Same thing with the will. You go see an attorney, pay $850 or so for a plan, and then the family comes to talk with that attorney, and the attorney says, great, now pay me thousands of dollars more, and we're going to get this done to probate your case. The do-it-yourself options. I'm involved in a probate case right now where this person did a do-it-yourself will, and I think I'm charging $2,000 more than I normally charge any person to do probate, and the money still is not going into the right place. So that's a huge risk if you're going to do this online. Again, the best step is to get an education. So I want to talk just a little bit about how you can get an education. I used to do a free initial consultation, which was nothing more than a glorified meet and greet and the sales pitch. I used to have clients come in and we talk and get to know each other, and I used to do it for free. And I just kind of give them some prices, and that was about it. And let them think on it, and I may or may not have ever heard from them again. But I learned and I grew and I developed what I call the family asset protection meeting, where it's more than just a meet and greet, where I have clients come in and we do an in-depth analysis of what it looks like for all of their assets, I provide an education. That's the reason why I charge for this service, is because it's not just a meet and greet. I am providing you with legal advice, and from that meeting, your takeaways are you can know whether a plan is good for you, or if nothing else, you can have all of your assets listed in one place, and that might just be valuable just to make sure that everyone knows what your assets are. Otherwise, you're in jeopardy of having your assets go to the government again, because we may not know what your assets are, and we have no other choice other than to do what we call a sheet, where we send it to the government and hope that someday someone does an unclaimed property on you. So I typically charge $500 for those, but for those of you who have attended this meeting, I do that for free. Yeah, and again, I do that just because it seems like you're interested in learning what an estate plan is, whether it's right for you, and I'm happy to help with that. And you can do that by either completing the survey that we're going to send to you afterwards, or you can do that by visiting this website here, the davidtfvp@as.me, and you can schedule it on your own. Initial meeting is the option you want to select. The only thing that I guess two things that I ask for is if you want to accept this, I just ask that you fill out the paperwork beforehand. We'll give you some paperwork to do, and that's really helpful for me to get that back before the appointment. And also just ask that if you need to reschedule your appointment, just give us about a day or two's notice. We're pretty booked out, and that interferes with my schedule quite a bit if someone cancels on the same day. That's because I have some other people waiting, and so if you're going to cancel, then I'm going to move someone up. So those are the only two things I ask for. I hope they're not hard asks, is to do the homework and show up to your appointment, or reschedule if you need to. So with that, again, want to thank you for attending, and we'll turn it over now to questions and answers. And if you'd like to, if you have questions, you can drop a message in the chat. I'm watching the chat now. If you don't like to use the chat, would rather ask me, just raise your hand. I believe there's a raise your hand option, and I will unmute you and I can talk to you about it. I'm just looking right now through the chat because I don't think I've seen anything come up during the webinar. Yeah, you guys have been kind of quiet. So we'll just give one more plug, and maybe there's just no questions, and hopefully maybe that means I taught you something. So yeah, just once again, if you have a question, drop it in the chat right here, and I'll be glad to answer your question. If you'd rather ask it the conventional way, then go ahead and raise your hand, and then I'll unmute you and we can talk. And if not, let's see. We got something here. What's the price difference between a will and a trust? Yeah, that's a good question. I'd say it's about $1,000, anywhere from about $1,000 to $2,000. And going back to what I said before, sometimes it's hard to answer that question because when it comes to a trust, there's an important element called funding, meaning that we need to title your assets to the trust. Now that's not a hard thing to do, but it does take some work. And sometimes clients pay me a little bit more to do that work. And sometimes clients will just accept like a form, like an instruction, sorry. So I either way, I make sure that the trust gets funded. It's just the amount of work that a client does compared to the work that I do. So I'd say, yeah, anywhere from about $1,000 to $2,000, depending on, sorry, just rephrase. A trust is anywhere from about $1,000 to $2,000 more, partly depending on the work that the client wants me to do. Hope that answers your question. And by the way, I don't know if I mentioned this before, I don't bill by the hour. So whenever clients come see me, I show them the 9 plans, and they just make a decision based upon what I show them. I'm trying to reduce that down to 3 just to avoid some confusion. So what's the difference between a revocable trust and an irrevocable trust? And the short answer is a lot. The irrevocable trust, so let me tell you just the legal definition is a revocable trust is a trust that you can change at any point during your life. So you can, for example, let's say you put together this comprehensive plan and you think it works well for you and your family. And then one day, oh, you remember that story about the wicked stepmom? That was a revocable trust. The two grantors, the two people who set it up, said, hey, at any time, we can change this, and that's what that wicked stepmom did. So that's a revocable trust. It's something you can change. An irrevocable trust is one that once it's been signed and inked, then you cannot change the trust terms. Why would you do that? It depends on the scenario. Let's see. There's some scenarios where you don't want to make a change because you're afraid that you may be influenced to make a change. For example, have a client right now who is starting with the early stages of Alzheimer's dementia, and he's looking to do an irrevocable trust solely so that someone can't influence him later and change it. That's his biggest fear. Some other purposes are for Medicaid. I would say Medicaid is the #1 reason why I do an irrevocable trust, because in order to qualify for the Medicaid benefits that I described earlier, it has to be an irrevocable trust. Irrevocable trusts require a great deal of consideration. You have to have the right parties in place. You have to have the right person running the show. You have to have the right buzzwords in order to accomplish what you're doing. So the one thing you can't do, I'm going on a, now I'll talk about this for a little bit. I hear this a lot, is I want to make an irrevocable trust so that I can protect my assets. It doesn't quite work that way like that in Idaho. And what I mean is in some states, you can set up an irrevocable trust, meaning you can't change it. And in the eyes of the law, in the eyes of the IRS, the bankruptcy courts, you no longer own that property. It doesn't quite work like that here in Idaho. There are some ways you can protect your assets, but I hear this a lot mostly from non-attorneys. CPA, I hate to say that, but like CPAs or people who think that they're advising clients will say, hey, create a trust and make it irrevocable so that way you're protected. That's not going to do it. That requires some very complex planning to make sure it's done right. So I hope that answers your question. That most clients will do a revocable trust unless there's some, advanced planning that's needed. Okay, the next question is, what documents do you bring with us for estate planning? Typically, my process is that I send you some homework, and that will describe all the documents that we need. For the first appointment, usually that intake sheet is enough, and it kind of depends too. If you own a business, I like to see the business ownership. Not a lot is needed at that first appointment, but if you set up a trust, then eventually I want to see everything because I want to put everything into a binder. And you may have seen someone who has a fancy binder that they did a trust with. The reason why we do a binder is because we want to put in there more than just the trust documents. We want to make it easy for your loved ones to pick up this binder and say, I know where to go. I know who to call. I know what the debts are. I know who the financial advisors are. I know who the CPAs are. And so usually with clients, they'll bring some basic documents to the first appointment, and then by the end, I want to see everything. We just want to make sure everything is in one place, so that way, when the time comes, they can pick up the binder and say, "Yeah, we know who to call." All right. Then the next question is, after a trust has been established, who administers the trust? And that's up to you on who administers it. You can choose that person. And I typically give some advice depending on the scenario. In most cases, it's the children. Usually they choose one child to administer it. If there's some fear about the children, then we'll talk about some options. But we have to consider how it's going to work logistically. Let me give you an example. There's some trust, I call this the Married for Love Trust, and there's some trust where we can protect some of the assets that are left behind by the first spouse who passes away. And we have to be careful on who administers that, because many times the clients will say, oh, it's okay if my child administers that. But just a minute, there's still one spouse surviving. There's one spouse still living. And do we really want to create a scenario where the spouse living has to approach a child or stepchild and say, hey, I'm ready for money from this trust? Probably not. So typically what I do is I advise my clients just based upon the situation. There are trustee options. I like to stay out of it. I feel like it's a bit of a conflict for me to draft a trust and say, by the way, now you guys can pay me more money to administer your trust. I would accept an advisory position where if they needed my help, they could hire me. This is pretty rare, but if they needed my help, they could hire me. CPAs are a good fit for trust administration. They typically bill by the hour, and they're relatively inexpensive, $80 to $120 an hour. Their work is usually maybe once a month or so. They have to cut a check, or maybe every few months. But I like that approach. Banks, I would say, are probably the best at administering a trust, just because with banks, that's all they do. There's people in their departments where that's all they do is administer trust, but they come at a cost. They want anywhere from 1% on the total trust value. Now, I don't mean to completely discredit them, because the theory behind it is that banks are supposed to invest that money and earn, their fees. But I just like to make sure the client knows what they're getting themselves into. So I'll take just a second too and expand on this. Who administers the trust? I try and make it as simple as possible for that person, whoever it is. And I put in my trust documents a lot of terms, and some of those terms may not be needed. But for example, I have terms about a life insurance policy, because I'm expecting that it's probably going to be a non-professional administering the trust. And so I just want them to be able to look at the table of contents and say, okay, there's a life insurance policy. What do I do? And then they can read about the life insurance policy. I also, in my practice, I will provide, I don't know if I want to call it a free initial consultation, but like an included consultation with the person who is up as trustee. So when you pass away and there's a trustee, again, probably a child, I'll talk with them for an hour, give them a handout, and that's usually the last I see of them. It's not too complicated. And if it is complicated, then I'll try and see that, and we'll pick someone else to do the trust administration beside your kid. All right, any other questions here? That's been some good questions. All right, so what is the process for putting my liquid assets, such as an IRA account, put into a trust? Well, the process typically involves working with your trusted advisors to structure it to the trust. And let me just take a second to say that when you own a trust, and if it's revocable, you can still do with the trust property what you want. If you decide to sell your home, you can sell your home. If you decide that you want to change your IRA benefits, you can change your IRA benefits. You can do with it what you want. So keep that in mind. But really what you're doing when you're setting up a trust is you are titling all of your assets to be part of that trust. And the house requires a quitclaim deed, meaning you work with either me or you go down to the title company and you create a new deed for your house. For your IRAs, your bank accounts, you typically will work with your financial advisors to get the right forms. And so it's a process. It is some legwork to get the things set up in a trust. The legwork is not too hard. It's just a matter of visiting, your local branch or your advisor. The hard part is understanding the strategy. I'm just going to take a minute because this question involved an IRA. And I can tell you that if you name your IRA if you name your trust as a beneficiary of an IRA account, if it's not structured correctly, then you're going to be taxed at 37.5%, which is an outrageous tax fee. Now, your IRA is going to be taxed no matter what, because that's the way an IRA works. It's a tax deferred account. But if you have it to where it goes to a trust, then, just one second here. If you have it to where you have it going to a trust, then yeah, it's going to be taxed a lot higher. Sorry, just making sure. I just heard a report of a loss of audio. Okay, so okay, so I hope that makes so what I'm getting at is it's the strategy. It's talking about the trade-offs of how you structure your assets to the trust. Are there going to be tax consequences? And if so, how can we avoid it? It can be easily avoided. It's just a matter of having that discussion with the attorney to say, here's what I want to do. Can I do it? Yes or no? And if not, then how can we do it? Okay, so I believe that is all the time we have. Okay, and it looks like all the questions, and I hope we got to everyone. And just wanted to, again, thank you for attending. And here's some information for you if you want to talk some more. Like I said, I don't bill by the hour, so if this is something that interests you and you want to learn more, just let me know. And you'll get a follow-up email talking a little bit more about that gift. I hope you take advantage of it. It's a good opportunity to get an education and determine, what's the best fit for you and your family. Thank you again, and I hope you all have a good rest of your day.